How to handle kidnapping crimes in Creek County. Few criminal charges carry the level of seriousness associated with kidnapping crimes. In Oklahoma, kidnapping is a felony offense that can expose a defendant to lengthy prison sentences, substantial fines, and lifelong consequences. In Creek County, prosecutors aggressively pursue kidnapping charges because the offense often involves allegations of violence, threats, domestic disputes, child custody conflicts, or other serious criminal conduct. If you or a loved one has been accused of kidnapping, understanding the nature of the charge, the potential penalties, and the importance of an immediate defense strategy is critical. What is kidnapping under Oklahoma law? Oklahoma's kidnapping statute is broader than many people realize. A person may be charged with kidnapping if they unlawfully seize, confine, abduct, carry away, or detain another person without lawful authority and with certain prohibited intentions. The offense does not always require transporting someone long distances or holding them for ransom. In some circumstances, merely preventing a person from leaving a location may result in kidnapping allegations. Because the statute covers a variety of conduct, kidnapping charges frequently arise in situations involving domestic disputes, custody disagreements, assaults, robberies, and other criminal investigations. Kidnapping is a felony offense. Kidnapping is generally prosecuted as a felony in Oklahoma. A conviction may result in a sentence of up to 20 years in prison, depending on the circumstances of the case. Certain aggravating circumstances can expose a defendant to even more severe penalties. In addition to incarceration, a conviction may affect employment opportunities, professional licenses, firearm rights, housing opportunities, and future criminal sentencing. Because the stakes are so high, defendants should take kidnapping allegations seriously from the moment they learn they are under investigation. Many kidnapping cases arise from domestic disputes. One of the most surprising aspects of Oklahoma kidnapping law is how frequently the charge appears in domestic situations. For example, prosecutors may file kidnapping charges when they allege that a person prevented another from leaving a residence, a spouse or partner was forcibly restrained, a victim was confined during an argument, or a child was taken or concealed in violation of legal custody rights. In many of these cases, the facts are heavily disputed. Witness credibility often becomes a major issue. What one person describes as being held against their will may be viewed very differently by another witness. Child-related kidnapping crimes can be especially serious. Oklahoma law contains separate offenses involving child stealing, custodial interference, and parental kidnapping. Parents are sometimes surprised to learn that custody disputes can lead to felony criminal investigations under certain circumstances. These cases frequently involve disputed custody orders, allegations of concealment, interstate travel with a child, and violations of visitation rights. Because child-related kidnapping allegations often overlap with family court proceedings, it is important to consider both the criminal and custody implications of the case. The state must prove every element beyond a reasonable doubt. Being accused of kidnapping does not mean the prosecution can prove the charge. To obtain a conviction, the state must prove every element of the offense beyond a reasonable doubt. Depending on the facts, important issues may include whether the alleged victim consented, whether any restraint actually occurred, whether the defendant acted unlawfully, whether the required criminal intent existed, and whether witness testimony is credible. Many kidnapping cases depend heavily upon witness statements, video evidence, text messages, and law enforcement testimony. A careful review of the evidence is often essential to identifying weaknesses in the prosecution's case. Constitutional defenses may be available. In some cases, the defense may challenge how law enforcement obtained evidence. Potential issues may involve illegal searches, improper interrogations, violations of the right to counsel, unlawful seizures, and coerced statements. If constitutional violations occurred during the investigation, certain evidence may be subject to suppression. Because these issues are highly fact-specific, an attorney should carefully examine the circumstances surrounding the arrest and investigation. Do not discuss the allegations with investigators. One of the most common mistakes people make is attempting to explain their side of the story directly to law enforcement. Investigators are trained to gather evidence and statements. Even innocent explanations may later be misunderstood or used against a defendant in court. If you become aware that you are under investigation for kidnapping, it is generally wise to exercise your right to remain silent and consult with an attorney before answering questions. Early intervention often matters for kidnapping crimes. The earliest stages of a kidnapping investigation are often the most important.
An attorney may be able to communicate with investigators, preserve favorable evidence, identify witnesses, challenge improper procedures, seek favorable bond conditions, or develop a defense strategy before formal charges are filed.
In many cases, opportunities that exist early in the investigation may disappear once the prosecution has fully committed to its theory of the case. Creek County criminal defense attorneys. Kidnapping crimes are among the most serious felony allegations prosecuted in Creek County. Convictions can result in lengthy prison sentences, substantial collateral consequences, and permanent damage to a person's reputation and future opportunities. Because kidnapping cases frequently involve complex factual disputes and severe potential penalties, anyone accused of kidnapping should seek experienced criminal defense representation as early as possible. Our criminal defense team at Creek County Attorneys is here to advocate for you. Call us at 918-209-3709 for a free and confidential consultation.